Good afternoon, everyone. Good morning to those of you joining us on the West Coast. Today, we're going to be talking about legacy planning. When people come to us and say, hey, I'd like to do an estate plan, I'd like to do legacy planning, what does that mean? What does all of that entail? This is the process that we engage our advisors and our advisors' clients with. It's a high-level outline of beginning the conversation, establishing what the process is, all of the considerations that need to be weighed for what we call estate planning 101. We believe when it comes to the legacy planning and estate planning process, you start with the basics first and you build up. Many times we have proposals and ideas that are brought to us where they're starting out in left field, or they're starting with a level 500 plan and they haven't done anything to address the basics. Today, we're going to talk about the foundation, the base upon which all planning should start and continue from. Our philosophy with legacy planning is you start with the simple things first. You get all of the basics down. Then you go to the 200 level and start talking about other strategies on top of those basics, then the 300 level, and if necessary, the 400 level. Anything that we do at C.O.R.E with regard to legacy planning, we are inside the box. We're not pushing any envelopes. We're not using any strategies that require opinion letters or non-disclosure agreements or any such thing. We believe that you can accomplish 90 to 95%, and it doesn't matter if you have $1 million or $1 billion. You can get the vast majority of what you need to get done staying inside of the box. And the rest of it, you probably shouldn't be doing it, right? If someone comes to you and says that they want you to sign a non-disclosure before they start talking to you about a concept, or you need an opinion letter, it's probably something that you're going to want to pass on. So legacy planning, our overview today is an introduction. C.O.R.E estate planning documents, sorry, pardon the pun, that's not core as in core us, as in what we consider basic or foundational documents. Inventories and beneficiaries, protecting assets and minimizing taxes, avoiding probate, planning for incapacity, family considerations, regular review and updates, and then recommendations on professional guidance. So what's a definition to estate planning? It's the process of arranging for the management and distribution of your assets during life and after death. When we talk about estate planning and legacy planning, it's not just about estate taxes. A lot of people focus on estate taxes when it comes to legacy planning. Yes, in some instances, the taxes are the primary issue, but when it comes to estate planning, it's the process and it's the documentation and it's the decisions and getting your affairs in order. And it's about protecting loved ones. These issues come up at the worst possible time, right? When someone's having a catastrophic event or someone's passing, or there's some trauma or tragedy in the family where these issues that we're going to talk about today come into play. Having these things in place and those mechanisms ready to go prior to there being an emergency protects your loved ones. It's also about minimizing taxes. It's about avoiding probate delays, and along with avoiding probate, avoiding attorneys' fees and attorneys having to deal with the courts and going to court to get permission to take certain steps. And it's about ensuring your wishes are honored, what your legacy is, what you want to have happen with the wealth that you've accumulated throughout your lifetime. What is it that you want to have happen with it? So, core estate planning documents. Will states how assets are distributed and names guardians for minor children. Trusts can avoid probate, protect privacy, and manage assets during incapacity. Power of attorney, and power of attorney is durable powers of attorney, medical powers of attorney. It appoints someone to handle financial and legal matters if you are unable. And these powers can be granted even before incapacity. You can have it so that an incapacitation is a triggering event. The issue with that happening that way is that at that point you're going to have to still go to court and get some type of a ruling that that person is incapacitated and the power of attorney kicks in. If you're in a trusting situation, um, for example, myself personally, my mother gave me power of attorney long before I needed to exercise power of attorney, so that when the time came that I needed to, it was a seamless step in, and it didn't require me to go get an attorney or go to the courthouse and get some certification done to have that durable power of attorney kick in. And then health proxies, a living will, medical directives. If you're in the, do you want heroic efforts in the event that you should become incapacitated and you go into a state that they need to revive you? Do you want that to happen? What are your wishes? And it's every individual gets to dictate that. So you have a living will and you have medical powers of attorney, and that gives those people the authority when dealing with the medical community as to how you're going to be treated in the event of incapacitation. Inventory and beneficiaries. Ask yourself, you know where all of your assets are, right? You'll have a pretty good idea, but even from time to time you forget about, oh, I forgot I had that little account, whatever. Who else in your life knows where all of your assets are? What banks you do business with, what insurance policies you have, what investment accounts do you have, what real estate do you own, how is it all titled? Who other than you, in the event you become incapacitated, is there someone in your life that's going to know where everything is, how to identify it, who to contact, who the sponsors, who the vendors are of those accounts? And then beneficiary designations. Who's the beneficiaries on your accounts? It's very important to review and update beneficiaries on retirement accounts, life insurance, and even payable on death accounts. Many states have passed legislation that you can put a pay on death or a transfer on death on just about any asset that you own, including real estate, motor vehicles, any type of an account. Most states have passed expansive rules that you can put transfer on death on accounts. But what are the common mistakes? Outdated beneficiaries. Whether you set up your 401k or you set up your IRA and it's been sitting there for 25 years. Your life has changed over those 25 years. The people in your life possibly could have changed over those 25 years. Have you gone back and looked? Because I will say that those beneficiary designations on annuities, life insurance, and IRAs the courts generally hold them sacrosanct. If the owner of the account is deceased, the court's like, were we to know the mind of the deceased person? I've only heard maybe one or two cases where the designated beneficiary was overturned on an account, even though it might have been, I heard one story, a guy he was 28 years old when he set up the account, and he named his girlfriend at the time beneficiary. And he went on with his life. They broke up, went their separate ways. And years later, he passed away in his 50s. And they went to find the beneficiary, and it was this ex-girlfriend from 30 years before. And she inherited the money, not his wife, not his kids, not his family. So failing to assign contingent beneficiaries. I think I try to impress upon clients that you should have contingent beneficiaries. Take the extra step. Think through what you want to have happen in the event your primary beneficiaries are no longer in the picture. And again, not updating regularly. We believe that, and we have a little process for your clients to say, hey, let's do a beneficiary designation review on all of your accounts that you've got named beneficiaries. Are they all current? It's another opportunity to deliver value to your clients, to engage with your clients on a customer service basis, to just help them understand, okay, where are all my assets and who have I named beneficiaries? This concept of overlooking digital assets. I watched an interview. I like to watch Margaret Hoover on Firing Line. She's on PBS, and she's kind of a conservative commentator. And she interviewed a woman who talked about her daughter's death. And they said one of the most difficult things was getting into their daughter's phone and getting into their Facebook accounts and their Instagram accounts and all of their digital accounts. They even had court orders mandating that these vendors, Apple and Facebook or Meta, whatever, and to release the records, and they still wouldn't do it. So this is a new topic about overlooking digital assets. Is we need to help our clients in this very digital age to address these issues and what resources and what things should be put in place so that in the event that they become incapacitated, someone, if just to go down and download their photo library, right? It's a lot more challenging than most people think or assume. And then assuming verbal promises are enough. Verbal promises are very, very, very difficult to enforce. Oh, so and so made a verbal promise to me that this is what I was going to get when they passed away. That's not how it works, right? I mean, if there's a document that says otherwise, it's a legal document, it's in good order, that's going to supersede any type of a verbal agreement. Protecting assets and minimizing taxes. You know, Ryan, who's on the call and he does fantastic work creating these presentations. And I always like to take a second. And what made me think is what our logo stands for. Up here, we've got the green, the yellow, the red, and this blue circle around it. And when we started many years ago, we had originally designed our talking piece as a castle with a moat around it. And it was kind of cheesy and cartoonish, and we modified it. And the green on ours stands for accumulation while you're working, growing your assets, building your wealth. The yellow was distribution. I've built my wealth. I want to retire. I want to start drawing down my assets and sustaining my lifestyle from the assets I've accumulated, the distribution phase. And then the red is the transfer phase. And that's okay. And that happens while you're alive. And it's kind of what we're talking about right now is the legacy phase. And most people assume legacy means death, and it's not. A lot of the best legacy planning happens while you're alive. And then the blue around it stood for a moat. You know, originally it was a moat. And what's here is preservation and protection. And on this, the reason I bring it up on this slide is about protecting assets and minimizing taxes. So properly done legacy planning will protect assets and minimize taxes. So life insurance is one of the tools. Core marketing, we are an IMO distributing life insurance, annuities, asset-based long-term care, disability income, and traditional long-term care, all of which are designed to accumulate wealth as well as to protect wealth. Life insurance provides liquidity to cover debts, taxes, and income replacement. In substantial estates, life insurance provides liquidity. The utility of life insurance creating liquidity at the most important time is undervalued. So I was working on a large estate planning case, and they were saying, well, what's the IRR on the second to die policy? And they were just looking at the IRR. And the IRR was actually very good out to life expectancy. It was a double-digit IRR when factoring in 40% estate taxes. But the other issue with this estate is it was 95% illiquid and 5% liquid. There's a need at death to inject a substantial amount of liquidity into that estate. It doesn't matter what the IRR is. It's the utility of having the liquidity to prevent or the forced liquidation of illiquid assets. Life insurance is a wonderful planning tool when it comes to legacy planning. Gifting strategies, reduce the estate size through annual and lifetime gift exclusions. You know, you've got your annual gift exclusion and you have your lifetime gift exemption. And, you know, the exemptions right now for a married couple are $30 million. Now, and it's supposed to be indexed for inflation. How long it'll be that level, I don't know. You know, there's a whole lot of people talking about eating the rich out there as far as the solution for, you know, all that ails our country. I don't buy into it, but I believe that there's a possibility in the future that the estate tax exemption levels could come down again, you know, in the $5 million range, $10 million person range with caps on wealth, all the stuff. Anyways, right now we got $30 million and we've been encouraging people in the plan to start utilizing some of that if they can. If they have more than enough and an abundance, to start transitioning some of the assets out of the estate today. Why? Because all of the growth on that asset will be captured out of the estate as well. So annual gifts whether it's you want to give money to your kids or your grandkids today for them to spend and do with what they want, or you want to set it aside and leverage it for greater wealth in the future. Plenty of great gifting strategies to help minimize the estate, reduce taxes, and capture future growth outside of the estate. And then trust for tax planning, irrevocable trusts. One of my favorite planning tools, and I have a mini presentation on, is an intentionally defective grantor trust, where you loan or sell assets to the trust, freezing the value of those assets in the trust. Because the trust is defective while the grantor is alive, the assets inside of the trust will go tax-free because the taxation passes through to the grantor's 1040. So whether it's an installment sale or a loan or an outright gift to an intentionally defective grantor trust, with or without insurance planning, insurance provides substantial leverage. But even if you were just taking an asset, an income generating asset, or an asset that's appreciating at greater than the AFR rate, you can capture a substantial amount of and freeze assets in the estate and can't capture substantial growth outside of the estate using irrevocable trust, intentionally defective grantor trust. And then you can set up within those trusts, you can set up insurance provisions, you can set up dynastic provisions where that trust could remain intact for generations to come, providing asset protection to the family. I always tell the story, the Kennedys lived a life of wealth and affluence, but Jack Kennedy, Robert Kennedy, Ted Kennedy, they didn't own anything. Everything was in trusts. Joe Kennedy put everything in trusts. They had free use of the houses in Florida and Maine and Massachusetts, and lived, again, lives of affluence, but they didn't own anything because it was all inside of trusts, and they were the beneficiary of the trusts, but those assets were protected. So, for example, and I bring it up, Ted Kennedy had an unfortunate event occur when he was a young man, and unfortunately, the woman that was with him at the time passed away. Had that family, and it was settled under the carpet, but had that family sued, Ted Kennedy didn't own anything. That's substantial asset protection through proper trust planning. And you can still, again, minimize the tax consequences of holding assets in those trusts by using defective trusts. Avoiding probate. Most states have a threshold for avoiding probate. They tend to range between $40,000, $75,000. In some states, it might be as high as $100,000 in assets. So if your family, if a person owns a house and has any type of equity in a house, they're going to be subject to probate. Probate can be a drawn-out process. One, theoretically, you could do it yourself and go file all the probate stuff. But at the time, usually when this stuff is happening, there's other things going on in the family's lives dealing with the loss than trying to figure out how to navigate going to the courthouse and start filing and beginning the probate process. So you're typically going to hire an attorney, pay legal fees. The attorney's going to go to the courthouse, have to do all the filings necessary to get the estate, get the executor appointed, get the estate up and running, so that you can start dealing with the issues. If you want to avoid probate, there's several ways, joint ownership with rights of survivorship. You can use transfer on death. Transfer on death designations avoid probate. If you have a non-qualified brokerage account, say at Charles Schwab, and you put a transfer on death, all you have to do is go to Schwab and provide evidence, proof of death, fill out the paperwork that Schwab requires, and you can take over as beneficiary of that account and avoid probate with that account. Life insurance, qualified plans, annuities, qualified or non-qualified, any type of contract that has a beneficiary named on that contract, all of those assets will avoid probate. And for the assets that don't have beneficiary designations, again, there's been a lot of expansive laws adding transfer on death opportunities on all kinds of asset classes. But you can also set up a revocable living trust, retitle your assets to the revocable living trust. I am not a fan of, well, you don't retitle your qualified plans because that would be a horrible taxable event. And with annuities and life insurance, typically the only time I'm a fan of naming the revocable trust, which would become irrevocable at death, as beneficiary of those policies, is that if you don't think the beneficiaries are going to be responsible with what they're going to receive from those annuities and life insurance. Then you might want to use a revocable living trust as beneficiary to set up guardrails to protect them from themselves. Otherwise, what you would, the real estate, as I said, the largest single asset in most people's lives is their home, their second home. Those should be titled through the revocable trust, in my opinion. I personally set up a revocable trust. I have retitled my real estate holdings all to the revocable living trust. Why? Because then it will avoid probate. The trustee of the at my death is able to control those properties, take care of them, and again, avoid the courts, avoid anything. You have your power of attorney, you have your trust documents, you have your trustee powers, and the vendors that you have to, whether it's a mortgage or it's the utilities or anyone that needs to be involved managing those properties, the trustee has that authority from day one to go ahead and take over. So again, there's ways to avoid probate. I think probate should be avoided, just because it makes everybody's life easier. And then planning for incapacity. And this is something a lot of people, when it comes to legacy planning, they kind of take for granted. Again, when we talk about legacy planning, in many people's minds, they're thinking about after I'm gone. Planning for incapacity is one of the most important parts of any type of a legacy plan. Again, why? Because when this type of thing, these decisions, critical decisions need to be made, it's usually at the worst possible time in everyone's lives. Some event has occurred where someone's in a hospital in critical condition, or someone's incapacitated, or someone has passed away, and the family's dealing with that aspect of it, caring for their loved one, worried about their well-being, or mourning their loss. And they're not dealing with all of the issues that are necessary to conduct the world doesn't stop, right? The day-to-day things don't stop. The utility bills don't stop coming in. Insurance premiums need to be paid. Taxes need to be paid. All those things, that stuff doesn't stop when someone becomes incapacitated. And so it's important, again, to have durable powers of attorney to manage financial matters. Just to pay bills, just to call up the utility and say, hey, I think that there's a late bill. They won't talk to you. And I'm sure many people in this had experienced that frustration where you're just trying to do the right thing and keep everything on even kilter while dealing with a crisis in the family. And the people, sorry, we can't talk to you. Durable powers of attorney avoids that situation. And again, healthcare directives. It doesn't happen. I haven't heard of it happening as much now as it did, 10, 20 years ago, where the medical providers, in absence of directives from the person that's ill, the one who's in critical condition, the one's incapacitated, the medical providers can start making decisions. And if there's no clear directive from the family, they can do whatever they want, right? Oh, well, we have an obligation to keep this person alive. We have an obligation to keep that bed filled. Whatever their motivation might be, if you have health directives, it makes it clear, and it also takes the pressure off the person who has medical powers of attorney. They're sitting there, and there's a decision to be made about whether you take heroic efforts to prolong someone's life or not, and it's someone they love. But if that person has already said, this is what my wishes are, it takes that burden of responsibility off of that person, and all they're doing is carrying out their loved one's wishes. And then long-term care planning. We have a presentation just on long-term care planning. And again, everyone thinks long-term care planning, when someone like me talks about it, all I'm talking about is selling long-term care policies. And it's far more than that. A long-term care policy is one part of long-term care planning solutions. It is the funding and the money part of it, right? What's the most efficient way to provide assets to pay for long-term care? But it's all about setting up a long-term care plan in the event that I need to go into long-term care. Medicare is not going to pay for it. Who's going to take care of mom if she wants to stay at home? Who in the family is going to do what? How are we going to coordinate efforts? What is the person's wishes? My mother's wishes were never to be a burden, right? And we put planning in place. She wanted planning in place so that should something happen, that she would never be a burden. And she meant it. And that planning was put in place. There's still a whole lot more to it than just saying, I don't want to be burden. But we put a plan in place. We had an understanding. We had a conversation, particularly in families where there's multiple siblings around or there's spouses involved. Who's going to take care? At what point do we go from staying at home to assisted living? What is that like? That is a long-term care plan. We have a fantastic one-page piece, if you're interested in it, to start the conversation with your clients. Long-term care and its associated expenses is the greatest financial risk your clients over age 65 face, right? 67% of people over the age of 65 will have a catastrophic long-term care event in their lives. It's going to require payment of expenses. It's going to require care. Where is it going to be? Who's going to provide that care? What are the resources the family brings? It's very important to have that conversation. Again, we have a separate breakout just on that concept, but if you're interested, you can email us after the call and we can send you the one piece engagement for the conversation. Family considerations. Guardianship for minor children. For your clients who have minor children, if something should happen to them, who do they want to be the guardian to take care and look out for their children, right? And it's a conversation that the person should be having with the person they're naming for guardianship. I've seen cases where an event took place and everybody's reading the trust and the will, and they're like, wait a minute, they named me guardian? I did not know, right? And so what do you do, right? If you're not prepared for that, it's an incredibly important conversation to have. Special needs planning. This is a very close to home topic for us. It's something that we as a company are focused on. My partner, Bob Petkoff, is engaged in a project right now to establish special needs planning and special needs resources. It's very near and dear to him. Special needs planning is, again, yes, there's the financial aspect of it where you set up a special needs trust, you figure out how to fund that trust. Why are you doing it? It's to keep assets outside of the beneficiary's estate so that they can qualify for the health insurance through Medicaid, other programs that are asset-based or wealth-based before you can qualify. You set up a special needs trust to provide for them and also have them get the benefits that they deserve from the state. Blended families, very common, careful planning to balance interests of spouses, ex-spouses, and children. This is a big topic of conversation. It comes up in pretty much every legacy planning. If there is a second marriage and it's a blended family, I was working a case, we were doing estate planning, we weren't doing estate planning, we were doing just cash flow modeling and projecting out, okay, can they get there from here? They've got these assets, these resources, they want to retire in so many years, and this is the lifestyle they want to live. Can we get there from here? And we did all this modeling, and we're getting ready to do the presentation. And then an email came in from the wife saying we're getting divorced. And they were just recently married, and they were a Brady Bunch family. They had 7 kids, 4 from one and 3 from the other, and it was this whole blended family thing. It was an interesting dynamic. Blended family conversations are very critical to have. There's a lot of great planning techniques where you can take care of the second spouse, and the children from the first marriage can still be taken care of, and there's all kinds of dynamics there, but it can all be done with proper planning and take all that angst and worry and conflict out of it at the time someone might pass. And then rules and responsibilities, choosing executors, trustees, and guardians thoughtfully. And again, encouraging your clients to have head-on conversations with the people that they want to name executor, trustee, and guardian for their family, for the beneficiaries. Preparing heirs for responsibilities. It's, if you're 25 years old and all of a sudden you inherit $5 million and nobody told you it was coming and it's more money than you ever thought you had, if I knew that if I had inherited $5 million at age 25, I don't know, I might not be here today, right? I might have had a grand old time and gone off like a comet. And I'm saying that tongue in cheek. It's important to prepare heirs, and I don't care if your kids are 40 or 50 years old and they're going to inherit a substantial amount of wealth. It's highly recommended that you engage with those beneficiaries, educate them as to what the wealth is and what's coming, and then help educate them as to how to handle it and deal with it. Now, some families are very closed-mouthed about that, and that is a family dynamic and a family decision to make. It's an option where hey, we're not telling the kids anything, and all of a sudden one day they're just going to have this thing, this edifice that we created, our legacy, dropped in their lap, and you know what? They can figure it out. We'll be dead. Delegating decision making, again, who do you want to make decisions for healthcare, proxies, power of attorney, to help out in the event of incapacitation? All of these are family conversations or family, friends, those that you care about conversations. And then regular reviews and updates. I always say to people, it's amazing to me. People say, "Oh, I have a revocable trust," and they bring this big binder in and they bring it in a desk, and it's like, okay, what assets are titled to the trust? What do you mean? If they don't title assets to the revocable trust, it's just an expensive doorstop. And it's important to sit down and review, have things been put in place that were originally discussed, have all the steps been executed, and then life circumstances change. You look back where you were 10 years and where you are today, and how close are the two together? Where you saw yourself being 10 years from now versus where you were 10 years ago, things change. And the documents need to be updated, kept valid, and aligned with your intentions. It'll prevent costly disputes, conflict in the family, and again, costly not just in a financial aspect, but I can't tell you how many times we've been helping families resolve estates, and the families are torn apart because there's ambiguities, and everyone's got an opinion, and everyone wants to argue about it. And it's amazing just how much a family can be torn apart because the person that's passed away hadn't made their wishes known. But keeping documents valid, updated with your intentions, prevent costly disputes, tax inefficiencies, and outdated instructions. Ensure loved ones know what your current wishes are. And again, it needs to be updated. When you were 40 years old, you might have said, this is how I want it. If I become incapacitated, this is what I want to have happen. But when you're 60 years old, you might have a different opinion. It's important to keep talking to people about that and updating your documents accordingly. And then encouraging participants to check their plans. We recommend a review every 3 to 5 years. After any major life event such as marriage, divorce, birth, adoption, death in the family. These are all critical events that can alter the course of what, my former father-in-law left his cottage to his son and his daughter, but his son predeceased him, and he hadn't updated his documents. Created a little bit of conflict in the family. Financial changes. Do you start a new business? Have you had significant growth in assets? I have a buddy of mine that bought NVIDIA 5 years ago. He's walking around thinking he's a genius, and what, pretty good move. His wealth has gone up substantially because of what he invested in NVIDIA. His plan for his future and for his legacy have changed. It's worth the conversation. And again, just selling a property. If you sell a property or you buy a new property, buy a vacation home, all of those things, it's time to readdress the overall plan. And then health changes. Serious illness, disability that can impact decisions. It's one thing to talk about it theoretically, but when you start down that path and you still have your wits about you, it's time to sit down, revisit the plan. Is this exactly what I wanted to have happen? And of course, law and tax changes. I've been in the business 33 years. The estate tax laws have probably changed 17 out of those 33 years. Income tax rates change. Capital gains rates taxes change. Estate tax changes. Gift tax. All these things change all the time. It's only as good as the next legislature, whether state or federal. So anytime there's substantial changes in the tax code, it's a time to sit down and revisit, okay, is our plan still valid? Do we still need to do what we've got set up? So these are all things, again, regular reviews and updates. And as a financial advisor with your clients, this is, again, a customer service issue, bringing up the questions, helping the client navigate through the questions. It's a tremendous value add to your clients. And then professional guidance. Why professional guidance matters. Legacy planning involves legal, tax, financial, and emotional complexities. Professionals can help avoid costly mistakes and ensure compliance with current laws. The other thing is that the professionals can do is remove the emotional aspect out of it, or be an honest arbiter in conversations between family members about, when making decisions, be that person that's bringing up the facts, the data, the numbers, the math, as opposed to just relying on the emotions and the psychology of what's going on in the family. Guidance provides objectivity in family sensitive decisions, right? I guess that said it a little more succinct than I just did. Key professionals to involve as an estate planning attorney. Someone like me, I'm well versed in the legal documentation, but I'm not an attorney. And I know that it's absolutely critical when you're drafting all of these documents that you involve a competent, experienced attorney to help with the wills, the trust, the powers of attorney, and the healthcare directives. Because the attorneys that I've worked with, they bring up questions every time that I didn't think to bring up when it came to drafting the documents and putting everything down to meet the client's wishes. Obviously, most of us come from it from a financial advisory or planning perspective. It helps structure assets, investments, retirement, cash flow. We can help verify for our clients, are their beneficiaries correct on all their investment accounts? On the non-qualified stuff, have they put transferred on death in place? Have they titled assets to the revocable living trust that are smart to title to the trust? We can help with all of those aspects of it, as well as talking about tax strategies. But then ultimately, a tax professional, CPA, should be involved to optimize estate, gift, and inheritance tax efficiency, and more importantly, to document it properly with the Internal Revenue Service. If you're going to be using up your lifetime exemption, it's important that you file the proper forms at the proper time, dot the I's, cross the T's, and have it all lined up. And CPAs are absolutely critical to getting the tax planning aspects of the legacy correct. An insurance specialist, I consider myself one of those. It's important to understand how life insurance, long-term care, and other liability coverages are in place. Are they structured properly? Are they funded correctly? What are we trying to do? What's the long-term goal with life insurance? Make sure we, one, decide which type of product's the best product, then structuring that product so that it performs properly long-term, whether it's maximizing death benefit over the long term or maximizing accumulation, minimizing income taxes, providing liquidity to deal with estate taxes. There's a myriad of planning that needs to take place with the insurances. Long-term care, again, asset-based long-term care provides a tremendous leverage tool for people to protect against the downside risk of catastrophic uncovered medical expenses. I joke with people, how much would you pay for an option, a call or a put, or some type of a straddle option to minimize your downside risk, to avoid a 20, 30, 40% loss to your portfolio because of an expense that you have a 67% chance of incurring? How much would you pay for that option? Business advisors, helping with succession planning for family businesses, continuation planning, executive retention, having business advisors. That's something we also are very good at here at C.O.R.E, is providing advice with regards to business planning, business succession, business transitions. And then if a person is so inclined, talking to a philanthropy consultant, someone that really intuitively understands all of the intricacies of philanthropy and giving, and what are all of your options, how much control can you retain, where's the best way? Do you set up a private foundation? Do you use a community foundation? Do you use donor advised funds? How do you do your charitable giving? Again, having someone that's specializes in that field is absolutely critical to getting it right. So as you can see, it's a comprehensive team of professionals. I would argue that our role, those of us that are on this call, our role is to act as the quarterback for the team, to talk to our clients, ask them what they want to have happen, and then help identify the optimal outcomes and the optimal solutions for all of these fields, and then help them coordinate. If they've got people, a CPA, and they've got an attorney that they work well with, then integrating all of them and everybody around as one team. Or if they don't have those resources, helping them identify those resources in your community to pull together a team to help your client achieve their legacy plan. So what legacy do you want to leave behind? We have a simple graphic, very simple. It's just kind of a planning flow chart. I provide this as here's the flow chart. When a client says, hey, I'd like to talk about legacy planning, what does that entail? We're happy to provide you that if you find this presentation useful, we're happy to provide you this presentation as well. I think it's a clear and concise. Here's laying out, here's the outline, here's all the moving parts, here's the process, here's the sequence of events that you need to go through. So this is where I'll pitch C.O.R.E, my commercial. We're very good at legacy planning. We're very good at helping you and your clients navigate through the process, provide resources, provide information, provide education. We can do modeling, where we just did a case last week where it's a very large estate. We were running cash flow models just to say, okay, the clients are currently 64 years old and their life expectancy is 25 years. They have these assets, and using the client's assumptions about inflation, rates of return, desired lifestyle, after-tax income desired, modeling out some projections using whatever assumptions the clients want to use, and saying, okay, here's what this looks like long term. It's something we do in a lot of cases. I do it for myself, even if we're not providing it to the client and I'm trying to get a handle on the numbers and the math. It's a useful tool just for your own internal use and modeling out where all the moving parts are in a client's estate. It's something we can provide. And then we can provide the coaching, the resources. Obviously, when it comes to the insurance planning, we can do all of the, we've got access to all the best products in the country. We've got a crackerjack underwriting team, case management team to get it through, case design team to help with the concepts, case management to get it across the goal line, and then be here long-term to help service the ideas and concepts that we help present. So that's our presentation today. I hope you found it worth your time. We're at 42 minutes past the hour. If you have any questions, concerns, please reach out to your relationship manager or call in and ask for a member of the case design team, and we'll be happy to answer questions and work with you in the near future. Thank you again for attending our presentation. Have a good afternoon.